Today, Rigathi is a thorn in the flesh of government. Can the state invoke the same provisions of Section 87 and bring Rigathi back here? Yes. Rigathi can be brought back and be charged over the same cases. Welcome to this week. This is a special week where we are celebrating 16 years since the Constitution of Kenya 2010 was promulgated. It was promulgated on the 27th of August 2010. Today, we are doing our special explainer from the Anti-Corruption Court. This is a specialized court under the Ethics and Anti-Corruption Act created to deal with crime related to economics crime. Today, we are looking at when Rigathi, that time, he was a member of parliament for Mathira. He was arrested in July 2021, brought to this court, charged with money laundering, charged with the offense of abuse of office, charged with the offense of acquisition of public property, and other related charges. In the Anti-Corruption Magistrate's Court here, case number E015 of 2021, the Republic charged Rigathi Gachagua as the first accused person. That time, he was a member of parliament for Mathira. William Wahome Mwangi, Anne Ndutaruo, Juliana Jehanda Makar, Samuel Murimi Reri, Grace Wamboi Karioki, Lawrence Kimaru, Irene Wamboi Ndigiriri, David Reuben Nyangi Nguru, and MS Rapid Medical Supplies Limited as the 10th accused person. They took plea over those charges. They pleaded not guilty. The case proceeded. Elections were conducted in 2022. Rigathi was the deputy running mate of President William Ruto. They won the elections and they were sworn in as president and deputy president. Then come on this day, that is on 10th November 2022, the state appeared before this court and made the following application. Through a letter dated November 3rd, 2022, by the Principal Prosecution Counsel, the Director of Public Prosecution seeks to have the present criminal case withdrawn against all the accused persons under Section 87A of the Criminal Procedure Code. The state argued that the application needs to be considered and the matter be withdrawn. Paragraph 4. All the accused persons, through their respective counsels, supported the prosecution's application to have the matter withdrawn under Section 87A of the Criminal Procedure Code. In paragraph 5, on cross-examination by senior counsel, Kyoko Kilukumi, my senior counsel friend, for the first accused, the investigating officer largely alluded to the contents of his affidavit dated November 2nd, 2022. However, he indicated that the investigating team acted based on a complaint from the Financial Reporting Center and that the matter wasn't politically instigated to harass and portray his client, Honorable Rigathi Gachagua, aka Rigathi, to the electorate as not being electable. It is common knowledge that Rigathi is now the Deputy President of the Republic of Kenya, whereas it came to my attention yesterday that the second accused, Honorable William Wahome Mwangi, is the current Senator of Nyeri County. Today, Senator Wahome Mwangi is a senator of Nyeri. I believe this is why the issue of political harassment has been taunted by the defense as being the sole motivation behind the arrest of the accused. Paragraph 7. Essentially, they are of the considered view that the first accused was the principal target in this matter, and the rest of the accused persons are merely collateral damage. Hence, the entire proceedings amount to an abuse of the due process. What did the judge say in paragraph 10? The judge says, this is not the judge, the magistrate says, there being no objection to the substantive application by the prosecution to have the matter withdrawn under Section 87A of the Criminal Procedure Code, the application is hereby granted as prayed. The accused persons are hereby informed that they may be rearrested in the future and the same or similar charges be preferred against them. However, as suggested by counsel for the third accused, I believe that it is important for courts of law to make recommendations that might improve the criminal justice system based on the real-time observations. I repeat, Vivian had to buy goggles to read this. The magistrate in paragraph 10 says, there being no objection to the substantive application by the prosecution to have the matter withdrawn under Section 87A of the Criminal Procedure Code, the application is hereby granted as prayed. Now here is where the big issue is. Rigathi is being told that the accused persons are hereby informed that they may be rearrested in the future and the same or similar charges be preferred against them. So the question, this is the decision of a magistrate called V. Wakumile, a senior principal magistrate then on 10th day of November 2022. In paragraph 25, the magistrate says, as we go about our official duties, it is always advisable to seek solace. Ameinua mikono juu magistrate. Ameshika kichwa. Anaomba. He's saying, I seek solace in our scriptures whenever one is overwhelmed. The magistrate was overwhelmed. In Matthew 7:2, the Bible says, and I quote, for in the same way you judge others, you'll be judged. And with the same measure you use, it will be measured to you. End of quote. The magistrate has raised up his hands and sought divine intervention and said, this job I do as a magistrate is similar to the jobs we do as advocates. The magistrate is crying and saying, I leave it. I have been overwhelmed in this matter. And goes to Matthew 7, verse 2. And he says, for in the same way you judge others, you'll be judged, and with the same measure you use, it will be measured to you. End of quote. What is the most fundamental issue here? The charges against Rigathi were withdrawn under Section 87A. But the magistrate warned Rigathi and his team that the state can pull up the same matter and bring it. Today, Rigathi is a thorn in the flesh of government. Can the state invoke the same provisions of Section 87 and bring Rigathi back here? Yes. Rigathi can be brought back and be charged over the same cases that he was. The matter was withdrawn. Rigathi was never acquitted. He was only, the charges were withdrawn under 87A. Can this be used in 2027 election? and Rigathi is brought back to this court? Yes. Can Rigathi rush to the High Court and say, you cannot bring me back to court? Rigathi cannot. Under 87A, the matter can be brought back if there is sufficient evidence. Honorable Wakumile warned Rigathi. Was this a plot to blackmail Rigathi and tell him, wind up your DCP party, or else we bring the charges back? This is a constitutional court. This is a constitutional Katiba week. We are bringing you explosive series. We have started with Rigathi. We are going to, are you aware, William Ruto was arrested and charged in Kibera law courts when he was a minister for education? Are you aware we have the asset recovery matter when Rigathi was taken before Justice Maina and his assets were forfeited to the state? Are you aware Babu Owino, the luminary of Linda Wananchi party, was arrested, and yours truly, Danson Omari, was his advocate, running through Kibera Law Courts, High Court, running through Justice Kimaru, and running through three. This is the Katiba week. We have decided to bring to you landmark decisions that have tested the Constitution since it came. Rigathi was arrested and charged 2021. His charges were withdrawn in 2022. There is a possibility that we are going to see Rigathi back here. From court helicopter, all the way from the anti-corruption court, Wakili Danson Omari. We thank Vivian for having looked for this research with his new crew, Kelsey. They have worked so hard to get this research during the Katiba. They are not enjoying the Katiba celebrations. They are busy looking for these authorities. Keep watching the 6 episodes about prominent politicians of 2027. How have they navigated from the anti-corruption court to the criminal court, the magistrate, to the asset recovery courts, to the constitutional high court division. Keep watching. Wakili Danson Omari.